Hi, I'm Matt Culkin, co-chair of StepToe's Financial Services Group, and welcome to another edition of the Financial Services University. Today we're going to talk about the Bank Secrecy Act and anti-money laundering regulation. I'm pleased to be joined by a colleague of mine, Evan Abrams, based in our Washington office. Evan works in our international trade and regulatory compliance and financial services practices. Evan advises fintech companies, financial institutions, and other businesses on compliance with anti-money laundering, economic sanctions, and other legal regimes. So, Evan, first, thanks for being here.
Yeah, absolutely. Thanks for having me, Matt.
And so I know we're going to talk a lot about recent changes in the AML legislative and regulatory landscape. So let's just start with the Anti-Money Laundering Act of 2020, and you can tell us what that is and why we should care. But I saw first that there's an expansion in the whistleblower front, and that seems pretty unique to me. And so maybe if we can just start with what is the law, and then we'll go into whistleblower.
Yeah, absolutely. So this is the Anti-Money Laundering Act, which was part of the National Defense Authorization Act, passed just at the beginning of this year. And it updates the Bank Secrecy Act, the main statutory regime that underpins the anti-money laundering regulatory regime, and made probably the most substantial changes to the Bank Secrecy Act in about 20 years or so. So significant changes across a number of different aspects of the regime. In terms of the whistleblower provisions, which you're right to call out as one of the most important provisions, the AMLA, as it's abbreviated, changed and really enhanced that so that whistleblowers can now receive up to 30% of assessed monetary penalties that are over $1 million. And previously, whistleblower rewards were generally capped at about $150,000. So obviously, big change. I should say the amount is discretionary, so one could receive a very significant amount or not very much at all, just depending on a number of factors. But it's a big change and one that may well lead to an increase in whistleblower activity. We've seen when other regimes like the SEC instituted whistleblower programs, quite a big uptick in whistleblower activity. And so it is early days here, but would not be surprised to see that under this regime as well.
That's really interesting. And I've seen even in my time in government, the whistleblower component can really change the enforcement agenda and effectiveness for an agency. I'm going to pivot slightly. I want to talk about no action letters. In my time working as a regulator, we had no action letters available as a tool pursuant to our regulations, and they were used pretty frequently for lots of different reasons. I noticed that the new law directs FinCEN to look into it. So I'm curious, what's required by Congress here, and where do you see that going?
Yeah, so Congress has required FinCEN to study the creation of a no-action process, and there is a process now where a member of industry could write in for an administrative ruling, but it's not really a formal process. For example, there are not timetables in which the agency needs to respond. So a lot of times industry will write in and you may not hear for many months or longer if it's a complicated issue. So FinCEN has, at the direction of Congress, now completed their study on this and indicated they intend to create a formal no-action process, which they're going to do likely later this year via rulemaking. And will probably be a real benefit for industry, especially the fintech sector, which often struggles to figure out how new technologies or products are captured under laws and regulations that really were written with other things in mind. So definitely something to keep an eye out for likely later this year, especially, as I said, for the fintech industry.
That's really interesting. I want to. I'm going to keep moving you forward, but in talking about this with you, you mentioned that there's an amendment in the law that requires certain compliance personnel of BSA regulated entities to be located here in the United States. And that seems to be just logistically a potential problem for non-US financial institutions. So what does that mean? And does that suggest that compliance officials are going to be moving to the US?
Yeah, this is a great question, and it's a provision that was in the AMLA that really wasn't reported on much or written about much. But as written, it requires persons who are responsible for establishing, maintaining, and implementing compliance programs to be in the U.S. And it's not clear from the statute if that means everybody. That just means senior officials like the compliance officer. It's not clear how it would apply to contractors or vendors, for example. So there's quite a bit of uncertainty there, and I think FinCEN will have to either put out some guidance or regulations to help industry understand what is and isn't required under that provision. And as you indicated, this is something that's primarily going to be of concern for financial institutions that are located and operate largely outside the United States, but may be subject to the anti-money laundering rules in the United States because they do at least some business here in the U.S.
I would, as I think about it, I would think from a compliance program adequacy perspective, you would want the knowledgeable official to be located with the business.
Yeah, and that's going to be tricky for companies that have built out really robust compliance functions that may be outside the United States, and that may be where, at least right now, they're real experts both on the business and on how the business meets its regulatory compliance obligations are located. So if they need to change that up significantly, it obviously could present both complications operationally for the business, but there's the potential there as well for slippage or inadvertent compliance issues to arise as personnel move around or change roles. So it is definitely something that I think particularly foreign located financial institutions should be thinking about. And like I said, hopefully we will get some guidance from FinCEN that will help those institutions think about it going forward.
Thanks. That's helpful. And so before I let you go, and you and I work together on a number of matters related to virtual currencies and blockchain technology. So I'm just curious, when you look into your crystal ball, what do you see happening in the next 6-12 months in the regulatory space as it relates to some of these novel products and issues?
Yeah, that's a good question. And blockchain, as you well know, has been a hot topic amongst regulators and lawmakers in the last several months. And from a FinCEN perspective, there are two ongoing rulemakings right now that impact the blockchain industry. Both of them have had a proposed rule that has come out. The comment period is closed, and industry is now waiting on a final rule to be issued. One relates to the travel rule, and it clarifies that virtual currencies are covered by the travel rule. It would also lower the applicability threshold for the travel rule for certain cross-border transactions. The other rule relates to so-called unhosted wallets and would require money services businesses and banks to collect certain information about their dealings with unhosted wallets, over $3,000, and then over $10,000 to actually report to FinCEN the information that they collected. And both of those have generated a fair amount of concern from industry across a variety of considerations in terms of how practical it will be for them to implement and comply, given the way the technology and compliance departments are set up. Privacy concerns is another one. So those are both, I think, rulemakings to track, and we may have a little more clarity on where those are going later this year. The last thing I will mention on this front is the Financial Action Task Force, which is the international standard setting body that puts out standards which most national anti-money laundering regulators meet. They are in the process of updating their guidance for virtual assets and what they call virtual asset service providers, and that is scheduled to come out likely around November and may have some pretty significant changes as compared to the earlier guidance. So something to keep an eye on there as well.
That sounded like the best teaser I've heard yet for a future financial services university course.
Well, I'll have to come back and do that. But yeah, there's no shortage of interesting developments in this space right now.
Well, thanks for coming on, Evan.
Absolutely. Thanks for having me.
So that does it for another episode of the Financial Services University. Please check out the remaining list of our courses. They're all published and available on YouTube, but of course at steptoe.com.